I mean, this just makes no sense at all. I've been a lawyer all my life. I have some idea of what is protected when you have a ongoing bit of litigation. Whether this individual has seen an official memo from within his own department is a very simple question to answer, and I think it's completely inappropriate to have this game of dodgem be pursued without any consequences. Well,
A Senate Finance Committee hearing grew increasingly tense when Senator Sheldon Whitehouse questioned Treasury Secretary Scott Bessent about a settlement connected to the release of confidential IRS tax information. Whitehouse repeatedly pressed for straightforward answers about the government's actions, while Bessent maintained that ongoing litigation limited what he could discuss publicly. Watch the exchange first, then we'll break down the arguments, the legal issues involved, and why the disagreement became so heated.
Have you identified any precedent in Treasury or IRS history for the agreement not to audit, investigate, or pursue any tax claims against the Trump family or businesses?
I can't identify any precedent where 400,000 tax returns, including the people you just mentioned and all of their employees, were leaked in a violation of one of the most sacred duties of the IRS.
So let me cut to that then. Senator. The leak was by a contractor. Can you tell me what contribution is being sought by Treasury or by the IRS for the harm done by the contractor? To a certain extent, your organization and the IRS are the victim of the contractor's malfeasance or negligence. What is being pursued by way of contribution by that contractor?
Well, the ranking member chastised me for cutting the contractor's contracts off, and we have removed their contracts, their ability to do business with Treasury and the IRS.
But there is no contribution into this particular case.
Again, Senator, you weren't here earlier, but I'm unable to discuss most of this because of ongoing litigation.
Yeah, I know everybody likes to say that, but the constitutional...
We like to follow the law, Senator.
And the law is that the Congress has constitutional oversight functions that do not disappear simply because there is litigation, however convenient it may be, by way of providing answers. So we have no precedent for it. No contribution is being sought from the contractor at fault. Was there any consideration to the government in return for the benefits of no audit, no investigation, no challenge or pursuit of refunds or other penalties?
Again, Senator, I'm unable to comment because of litigation. Treasury is represented by the Department of Justice in all matters. They act as our attorneys, so I would suggest that you direct your questions to Acting Attorney General Blanche.
Yeah, well, I've had a lot of times people who are before us invite me to ask my questions of somebody who's not before us, but you're the one who is before us, and I think you ought to know if there was any consideration offered or paid in return for that settlement. It's a very simple fact question. Was there or was there not consideration?
Again, there's ongoing litigation, and I suggest that you speak with the Treasury attorneys.
If this kind of behavior is okay with the chairman, I'll just pursue other questions. But, you know, what goes around comes around in terms of dodging questions.
I believe it's very clear that witnesses of any kind cannot discuss ongoing litigation.
They can certainly discuss a fact that they are aware of. The fact that there is some litigation out there doesn't mean that a witness can't say, yeah, there was no consideration, or yes, there was consideration. Was there a defense analysis memo? It's referenced in the judge's decision in Florida. Was there a defense analysis memo prepared by the IRS? And more specifically, did you see it?
Again, I'm not going to be able to comment on these matters.
Mr. Chairman, this just makes no sense at all. I've been a lawyer all my life. I have some idea of what is protected when you have a ongoing bit of litigation. whether this individual has seen an official memo from within his own department is a very simple question to answer. And I think it's completely inappropriate to have this game of dodgem be pursued without any consequences. Well, last of all, here's another question. Was there any analysis of what harm befell President Trump from having his taxes released when every president since Nixon released their taxes and he had promised to? Did anybody analyze whether there was actually any harm at all to him in those circumstances?
So there was a crime. President's rights under 6103 of the IRS code was violated, and equally as important, 400,000 taxpayers had that right violated, including every employee of the Trump administration, the housekeepers at Doral, the greenskeepers, the cashiers.
And you're welcome to
none of you
pursue all of
seem to
that,
care.
but it doesn't answer the question of whether the president actually suffered harm. And you're not answering that question either.
What made this exchange noteworthy was not the underlying tax leak itself. The central conflict was about something that frequently appears in congressional oversight hearings, where the line exists between legitimate legal restrictions and a witness's obligation to answer questions from Congress. Senator Sheldon Whitehouse approached the hearing with a series of straightforward factual questions. His focus was not primarily on whether the tax information leak occurred. Both sides appeared to acknowledge that confidential taxpayer information had been improperly disclosed. Instead, Whitehouse focused on what happened afterward. Specifically, he wanted answers regarding a settlement, whether any consideration was exchanged, whether internal analyses existed, and whether Treasury officials had reviewed relevant documents. Throughout the exchange, Whitehouse repeatedly framed his questions as factual rather than legal. His argument was essentially that certain answers should not require discussing litigation strategy or privileged communications. From his perspective, a witness should be able to answer whether a document exists, whether they have seen it, or whether specific actions were taken. Secretary Bessent took a different approach. His responses consistently emphasized ongoing litigation and the advice of government attorneys. Rather than discussing the details Whitehouse requested, he repeatedly stated that legal proceedings limited his ability to comment publicly. This created the central tension of the hearing. Whitehouse argued that litigation was being used too broadly as a reason not to answer questions. Bessent argued that legal obligations required caution. That disagreement is common during congressional oversight proceedings. Lawmakers often believe witnesses are withholding information that could be disclosed. Witnesses often believe that answering certain questions could affect ongoing cases, expose the government to legal risk, or conflict with advice from counsel. Neither side typically agrees on where the line should be drawn. One of the most important moments occurred when Whitehouse emphasized Congress's constitutional oversight responsibilities. His point was that Congress cannot effectively perform oversight if witnesses refuse to answer routine factual questions whenever litigation exists. This is a recurring issue in Washington. Congressional committees are tasked with gathering information, monitoring executive branch activities, and evaluating government decisions. When witnesses decline to answer questions, lawmakers frequently argue that oversight becomes less effective. Supporters of Whitehouse's position would likely argue that transparency is essential for accountability. They might contend that Congress cannot evaluate government actions without receiving direct answers from officials responsible for those actions. Supporters of Bessent's position would likely respond that legal proceedings impose real constraints and that government officials must be careful not to compromise ongoing cases. They might argue that protecting litigation interests is itself a legitimate government responsibility. Another notable aspect of the hearing was the difference in how the two men viewed the nature of the questions. Whitehouse repeatedly described his questions as simple factual inquiries. Bessent repeatedly treated them as matters connected to ongoing litigation. That difference shaped nearly every exchange. The senator believed he was asking for basic information. The secretary believed those questions touched matters that could not be discussed publicly. Because they disagreed about the premise of the questions themselves, meaningful resolution became difficult. The hearing also highlighted broader concerns about taxpayer privacy. Bessent repeatedly emphasized that confidential tax information had been improperly disclosed. His responses stressed that the rights of taxpayers had been violated and that the issue extended beyond any single individual. This point is significant because federal tax information receives some of the strongest privacy protections in American law. Regardless of political affiliation, many policymakers agree that taxpayer records should remain protected except in narrowly defined circumstances. By emphasizing the rights of hundreds of thousands of affected taxpayers, Bessent attempted to shift the discussion toward the broader privacy implications of the leak. Whitehouse, however, remained focused on the government's response. His questions consistently returned to what actions were taken after the disclosure occurred. This difference in focus explains much of the hearing's tension. One participant emphasized the violation itself. The other emphasized accountability for how the government handled the aftermath. Neither issue is necessarily incompatible with the other. But because each side prioritized a different concern, the conversation repeatedly circled back to the same points. The most memorable moment came when Whitehouse openly expressed frustration with what he viewed as evasive answers. His comments about a game of dodgeball reflected a broader complaint often heard during oversight hearings. Lawmakers frequently become frustrated when witnesses provide procedural or legal explanations instead of direct answers. Whether that frustration is justified depends largely on one's perspective. Some viewers may conclude that the witness was appropriately cautious. Others may conclude that legitimate questions were not being answered. That difference in interpretation is one reason hearings like this attract attention. They are not merely exchanges of information. They are also public tests of credibility, transparency, and accountability. By the end of the hearing, the central dispute remained unresolved. Whitehouse continued to argue that straightforward answers were being withheld. Bessent continued to argue that legal constraints limited what he could discuss. Neither side appeared satisfied with the other's explanation. Yet that unresolved tension is precisely what made the exchange noteworthy. The hearing raised broader questions about congressional oversight, executive branch accountability, taxpayer privacy, and the role litigation plays in limiting public disclosures. Those issues extend far beyond the specific facts of this case. They touch on fundamental questions about how government institutions interact with one another and how public officials balance transparency with legal obligations. Whether viewers side more with Whitehouse's insistence on answers or Bessent's emphasis on legal caution, the hearing offered a clear example of the friction that often emerges when oversight responsibilities collide with ongoing litigation. And that friction remains one of the defining features of congressional investigations and public accountability hearings.